that it's difficult to get a trial judge to also dedicate his time to a JSC judge, and we're thinking of hiring a specific ADR judge, right? But we do need that cadre of yeah. Well, there's another thing. Okay. So there's another thing that lawyers should start looking at as well, which is E&Es. E&Es, early neutral evaluation. And take the rundown actions, for example. You can open up a whole new business here of lawyers who are offering the services of offering early neutral evaluations. So you have two lawyers who are in dispute in a rundown action, and they want to get an evaluation of the case based on the pleadings, based on the damages. Perhaps you can, and it's better used for arriving at the assessment of damages, at a figure that they can agree. Send it to a lawyer who can look at what you say in terms of what's your opinion on quantum, and have him deliver a neutral evaluation on what a court may award as damages if it goes to trial based on the evidence as you have it. I mean, that's something for the Law Association to take up, and it's another ADR mechanism that we can look at. I used the E&E twice in run-and-down actions where parties were at odds on damages, and that was the only issue. And I said, look, I'll render a written advice on the damages, but it is confidential, not to be shown to the master, not to be revealed to your trial judge to determine the question of damages, and it's only for the purposes of assisting you to arrive at an agreed figure. And in those two cases, it worked. They looked at it, you know, right. So I just want to say something about these basic skills and also creating the right environment. This is what we need to do: build trust, empathetic listening, and so on, empowering parties. If you see this as the skills to be employed by your case managing judge, you would see a transformation of how we even approach litigation. All right? And that's the transformation I was talking about. People want to fight, and they come to us to fight. So we encourage them to fight if we take the approach that we go into trial, and let's go plead. But if we change our approach in how we speak to people, how we reframe questions, how we encourage open communication, people will realize, look, we're hoping that process filters back down. Yes.
In case management, when you say open communication, are you talking only from the attorneys or
Both.
parties as well?
Both.
Are the judges encouraging parties?
Well, I ask permission from the lawyers. I say, can the parties talk? And right there, they could get the apology if they want an apology. Right there, they'll say, look, all I really want is some respect, and that's the open communication. And that's why the rules say we want the parties then present in court. Yeah. Yeah. I know. Yes. So this is, and why I'm saying, Fraser, is that for me is the fallout of a JSC judge being trained in mediation and using those skills in a CMC room. All right. So if we're stuck, some of the things that we do, the same things that you all do, ask why, shuttle, caucus. Now the big issue in JSCs is caucus. Should the judge caucus? Should a judge, and remember I told you about why they come to us, the status of the judge. Should the judge go off into a room and hold private talks? All right? So the school of thought out there in the academic world is divided. All right? Some jurisdictions say we shouldn't do it. Some say why not? And again, it all depends upon the skill and training of the judge and how they handle that. Bottom line is you want to remove the perception of bias. You want to remove the perception of unfairness. You want to remove the perception of corruption. Okay? So you have to have ultimate trust of parties in that process. So if they want a caucus, they have to buy into the fact that I'm going to go off and I'm going to go off with you. They have to buy into that. But here's, I mean, it's the devil in the works, because the lawyers, if there's a change in attorneys, all right, and the agreement, they're looking for any loophole to the agreement, and the first thing they will say is, well, duress, and so on and so on. So look, as we get on with GSEs and mediations, we're going to see a whole new world of interesting, issues that we'll have to work through. So just to wrap up, we have to take care in agreement drafting, and my beef in creativity is still unlocking parties' minds from if there's a damages claim to resolving that matter on monetary compensation. And in GSEs, I always try to invite parties, but think about something else. Like medical negligence claims, I say, well, what about a donation? What about a scholarship? What about helping the children of the deceased with schools and fees? And so those are some things I throw at them. There are only 2 examples of creativity that I've come across, which is the apologies always work. I mean, we have not seen an apology in an agreement, but it is when they apologize, then they are able to get to the agreement of a money payment. There was one creative solution where parties were fighting over monies due for the rental of chairs in a fete in the Queen's Park Savannah. And so the rental company brought the claim against the promoter. And because the promoter didn't pay for the chairs, right? The promoter is also the owner of a radio station, or he does work in a radio station. And they settled the claim by giving the chair owners free ads and free spots. So that's a way of creative thinking, And it just so happened that the people who had the chairs, they had some big entertainment thing coming up, so it worked out, You wanted to say something? No. Right, okay. Expect the unexpected in GSEs like any mediation. We've had the lying litigant. And with the lying litigant, the school is out on this. It's obvious to me that somebody is lying, and I started cross-examining that person in the GS. The attorney's hat came on, and that's when, and I think this is where the training exercise has to come in. Is that the role of the GSE judge to really take on that real adversarial position? And maybe he should. Maybe there should be a wake-up call. And maybe after that cross-examination, the lawyer would have spoken to that client overnight and say, hey, you're really talking nonsense. Sorry? And it would have been based on my opinion. And, yeah, exactly. The boisterous litigant, I have had people come in and hitting the desk and shouting, and the same challenges that you have, and you have to cool them down. Didn't happen often. Actually, it happened twice. Well, this is a lovely one. You come to the agreement, and the fellow say, well, okay, I'll sign next week. Man, go and leave the country, So what I did, I said, well, what to do? You didn't sign it, well, there you go. The silent litigant, you have to be careful. I mean, again, you're trying to engage parties. You're trying to, there was a case where a death claim, and the mother of the deceased was there, and she was very quiet. She wanted the lawyers to speak. But it's only when she was engaged, and I had to have 3 sessions. And every session, you'd see her becoming a little more bolder about it, and the matter was settled. The trusting litigant, be careful of the one who's currying favor with the judge. When I did one, they sent me a coffee cup with my name as a gift. And I was wondering whether I should use it or not. So I sent it back, so again, so you see the whole issue. And then it just so happened that was the same one when we went to do a site visit. She was inviting me in the house to have some drinks and let everybody come across. And as a judge, you have to decide now which house to go in to have these drinks, or if at all, right? And then you don't know what you're drinking. So anyway, there you go. And then the handicapped, you have to be careful about how we deal with the vulnerable. And one strategy I use is that I ask them to bring the victim of a road accident in a wheelchair. And he was paralyzed from the neck down. I did that after the first session. We weren't getting anywhere. I said, bring him. And when they wheeled him in, I think within 45 minutes, the insurance company, in fact, the mother in that case said, I will always remember this. We were fighting over multipliers, multiplicand, lost earnings, and we're going through this thing. And she said, you could give me $1 million, or you could give me $1. You can never give me back my son. And, I mean, we all just fell silent. We worked out, sadly in that case for me, we worked out a compensation deal. But what else could we have done to really, help that family? So this is us here, going boldly where no man has gone before. Justice. So we have Justice Devines. So Justice Devines is in the we have Spock and we have Uhura and Pemberton. Well, Mondesir is hiding somewhere, but anyway, he's not here. Right? Okay. So that's it, folks, for GSEs. And we have Grenada here, right? Grenada. I'll just leave you with this point, that how important it is for us to try to resolve a claim holistically. There was a claim where there was a dispute between two companies, but clearly this dispute was spilling over in other jurisdictions in the Caribbean, where there was some property being owned elsewhere. And here we could take the approach of, okay, we're going to go to trial and solve one problem, but what's going to happen with other stuff? So it went to mediation. It wasn't a settlement conference. And they were able to work out the entire. What we did learn is that in the other jurisdiction, there was other litigation. And that other litigation came about after this one was filed in Trinidad. And I thought it was a beautiful case study on a dispute gone viral. Outbreak, if you don't solve it, it's just going through the Caribbean. So I think for us in the judiciary, this is something that the judges are embracing. And for us, it's changing our style of dealing with people, because at the end of the day, litigants want real solutions and to be treated humanely. So unless there's any other questions, folks, that's it. This is purely voluntary. Yeah, it's voluntary, but they don't walk out, right? Before a judge, right? They don't walk out. I'm wondering if anybody ever did walk out, but they threatened to. But the ground rule is, like in a mediation, if you feel that you want to end the session, it's voluntary, it's entirely up to you. But let's agree that you'll have a little word with me about it, and let's see if we could try to resolve some issues. Yes, Sasha, you wanted to say something.
I just want to reiterate, the only thing that makes the mediation agreement or the GSC agreement binding is if it becomes part of the substantive matter.
Well, once you've signed the agreement, that's an agreement.
So you take action against that agreement if there's a problem.
That's my view. So if you don't have it, so if you don't enter it as an order, I mean, the advantage of entering it as an order is that you have an order which can be enforced in court. But equally, you have an agreement. But the practical issue you have to consider is you have to file a fresh action on the agreement. Possibly, you may have to amend your pleadings if you wish and include the agreement as part of the case. Excellent, yes. Or enforcing it. Excellent. Well, I'll tell you, parties have gone to, this is a mediation without their lawyers. And they arrived at an agreement, and the agreement was sent to me. But when they came before me, the lawyers objected to the agreement because they said they didn't get legal advice and it's not a good agreement. And I did not enter into the consent order because the lawyers didn't give their consent to the parties. Conceptually, one party could have taken an action against the other and say that there was an agreement. But, yeah.
My last question is, we know that matters before they conclude could be referred to mediation or GSC. What about if a substantive traditional matter in court of judgment has been arrived at? Is there any room for taking that?
That's the next, okay, that's a new,
Topical now in Trinidad.
what, you mean after judgment given? Yeah, all right, so that's the next new rule. Because you have arbitrations, ARB-MEDs, MED-ARBs, MED-ARB-MEDs, so why can't we have MED-JUD-MED? No, it shouldn't. Especially, let's take land disputes. I give a decision on a land dispute, all right? Question of somebody breaking down a wall, boundary dispute, and so on. Why can't you go now and have a mediation to work out things like understanding what the judge said, understanding the mechanics of doing it, how to implement it? Because conceptually, again, if you appeal, all right, and this is to come, the appellate court may soon introduce court-annexed mediation